Well, Supreme Court Justice Antonin Scalia, known as a conservative, is under fire now from some liberal lawmakers and civil rights activists for comments he made during the oral arguments last week over the future of the Voting Rights Act. Now, this is a law that makes these states with a history of discrimination have to report to the feds and get a permission slip, basically, before they change their voting laws, because there's a concern they'll do something that is damaging to minorities attempting to vote. Justice Scalia seemed to suggest that the federal government no longer needs to keep an eye on Southern voting in this way, that folks can just bring individual lawsuits if there are cases of discrimination like they do up north. And the way he phrased it, saying what Congress is doing is voting for a, quote, racial entitlement, got some people very fired up, including Democratic South Carolina Congressman Jim Clyburn. He's the third most powerful Democrat in the House, who slammed Justice Scalia, saying in part, quote, "I'm not easily surprised by anything, but that took me to a place I haven't been in a long time. What Justice Scalia said to me was, the 15th Amendment of the Constitution ain't got no concerns for me because I'm white and proud." Joining me now is Jay Sekulow, Chief Counsel for the American Center for Law and Justice, and Julian Epstein, former Chief Counsel for the House Judiciary Committee. I mean, that's pretty incendiary to suggest that Justice Scalia, in trying to make his point up there, was really trying to communicate, I'm white and I'm proud. Let me start with you on this, Julian.
I would not have used that language. It's not at all the characterization I would have used for Justice Scalia. I also wouldn't have used Justice Scalia's term about the Voting Rights Act being a racial entitlement. The Voting Rights Act was passed, renewed in 2006 with almost unanimous support, including support from Republicans, and it's done a lot of good. In Mississippi, there was this requirement in 97 you had to register twice, and the Voting Rights Act pre-clearance struck that down. Everybody agreed with that, including Republicans. In the year 2002, when Arizona passed a redistricting law that could disenfranchise lots of Hispanics, the Bush Justice Department struck that down. So I think it wasn't the right thing necessarily for Congressman Clyburn to use that language. I wouldn't have used it. I respect him. He's a friend. I think he's a wonderful guy. But I also think that Justice Scalia's term and calling this a racial entitlement was not quite in keeping with the bipartisan history of this.
Jay, before we move on to the substance of it, and Julian got to that,
sure,
as his second point. You know, I took issue with this last week with some others name-calling against Justice Scalia.
Right.
The reason, in part, it bothers me as somebody who covered the High Court for years and practiced law for years is you got to understand these Supreme Court justices cannot come out and defend themselves. They don't speak publicly.
Right.
They don't get the opportunity to come out and say, "Oh, this is why I said that," and and then to say, "Look, that's unfair," because we're so lucky that all 9 of these justices, those on the left and those on the right, are willing to serve us. They could all be earning millions of dollars out there in private practice, but they're willing to serve, and they have to sit there like sitting ducks and take, fine, they can take their licks, and I'm sure they can take these too, but as a lawyer, does it not bother you to hear that kind of charge?
Well, as a lawyer at the practices of the Supreme Court, you know, in addition to being admitted to the bar of the court, you're an officer of the court. As an officer of the Supreme Court of the United States, I find it actually despicable that the congressman would use that kind of language about a sitting justice of the Supreme Court, whose statements were not that out of a legal mindset. And the legal mindset that Justice Scalia was talking about, the legal theory was saying is, look, a law was passed a half a decade ago. Facts have changed. Those factual changes may, in fact, impact the constitutionality of that statute that is a half a decade old. That's not some controversial statement. The media is making this out to be, and some on the left are making this out to be, as if Justice Scalia's made some racial statement that's inappropriate. He did nothing of the sort. All he said was pointing out a fact. If you look at the facts now, Massachusetts had the worst ratio of voting as far as minority voting goes and white majority voting goes. Massachusetts was the worst. So when you look at a law that's been in place for over a half a decade, you say, you know, facts and circumstances can change. That will impact the constitutionality of that statute. That shouldn't be a controversial statement, but the fact that he said it's being voted on almost on autopilot, which it is in the Congress, he says, you know, it gives this look that it's just kind of this racial preference, that we're just going to do this because we've always been doing it. Again, not a controversial statement, but you're right, Megan. He doesn't get to defend himself, although as someone that's been on the receiving end of Justice Scalia's questions, I will tell you he is quite capable of doing just that.
Oh, yeah, he doesn't need me, he doesn't need you, but it bothers me.
Nope.
I don't like it. I've defended Justice Ginsburg when people do this
you're
to
right.
her as well. And by the way, those two are said to be best friends, Justice Ginsburg and Justice Scalia. So it just shows you, the left and the right on the high court can get along. Why not in the rest of the country? But Julian, that's a bigger problem we're not going to solve here today. On the question of Justice Scalia, the accusation by some has been that some on the left are using this. They're trying to gin up controversy about this, trying to paint Justice Scalia as a racist or insensitive racially, when it's understood that what he was trying to say was sort of what you were saying, which is they passed unanimously in the last vote, and he was saying that the numbers of folks voting for the Voting Rights Act has gone up and up and up over the decades, as indisputably the discrimination at the polls, while still present, has gone down and down and down. And he was saying the reason politicians do that is because they don't want to be seen as voting against the Voting Rights Act, and so you may need the high court to come in and say, all right, look, it's no longer necessary.
Right.
Well, look, I don't know that I would associate myself with Justice Scalia's comments. I think the objections on the left were because of the use of the word racial entitlement as a pejorative term for something that has been agreed to on a bipartisan basis is a problem that continues to exist. Well, I think that's in the eyes of the beholder. So I think
people need to listen. Julian, before you accuse the Justice of the Supreme Court of using a racial statement as pejorative, look at the transcript, read the transcript of what he actually said. He made a point that is a legal point. This act has been put in place. There's no doubt that in the decades that have come since the Civil Rights Act was passed, things have changed. That may affect the constitutionality, and it seems to him, as an observer of this, that politically it's on autopilot.
Okay, go ahead, Julian. Julian, you have the floor.
I was trying to respond to a question before you interrupted me. So my point is that I think many on the left saw that.
Jay's upset today, Julian. Go ahead.
I think many on the left and others saw it as a pejorative term, as using the word entitlement, because the purpose of the Voting Rights Act is to remedy discrimination that's ongoing. And I think if you look at, I think the bottom line here is that the act is in trouble. I've predicted every case pretty accurately on the show. I am doubtful as to whether it will actually survive constitutional scrutiny. I think it should, because I think if you look at the covered states like Louisiana and Mississippi and Georgia and South Carolina and Virginia, they still are, if you look at the state legislatures, they still are the most underrepresented states in terms of minority representation in the state legislatures. If you look at ongoing issues that we have, like redistricting, redistricting has become just an unbelievable mess, with gerrymandering going on in many, many states, and it has gerrymandering going on for political purposes, whether or not there's a racial tinge there or not, is what the dispute is about. But there's no questioning that gerrymandering is a terrible problem. We've talked on this show about voter IDs. So, we've talked about voter ID before. Jay, just let me finish the point. I don't interrupt you.
Quickly.
So,
well, you're taking a long time to get to it.
I think you've had a little more than I have.
Julian,
the point on voter IDs. The point on voter IDs is, again, another issue where you had potentially 21 million people disenfranchised from voter IDs to cure a problem that everyone didn't agree agrees doesn't exist.
Okay.
Okay, great. Voter IDs, though, are not
what's
at issue here. What's at issue here is a statement that was made about a sitting justice of the Supreme Court of the United States who's basically accused of being a racist because he made a statement that said it seems to him that the legislation is automatically renewed as if it was an entitlement, and things changed in 50 years, and Massachusetts has the worst voting proportionate representation of minorities, including black citizens in the United States, and Mississippi, by the way, has the highest ratio. So this whole idea that what Justice Scalia said, and that was the topic we're supposed to be discussing, and the attack on him is ridiculous. And frankly, Megan, I find it a bit repulsive as an officer of the court that a member of the United States Congress would do that.
All right. Thank you both so much.